Good afternoon, everyone. Welcome to the First District Court of Appeal. We have two cases on the docket. The first one is Florida Springs Council versus DEP St. John's Water Management District and the Southwest Florida Water Management District. It's 25-1369. Counsel for Appellant, are you ready?
Yes, Your Honor.
You may start.
Thank you, Your Honor. Good afternoon, and may it please the Court. I would like to reserve 5 minutes for rebuttal. My name is Matt Farmer with Doug McLaughlin. We represent the Florida Springs Council. The challenge in this case regards a proposed rule from 2025 that for...
Can you pull the mic a little closer to you?
Yes.
Just grab it right there and do it like that. There you go.
Thank you. This challenge is to propose rules from 2025 that apply exclusively to Florida Springs, outstanding Florida Springs, which adopt verbatim pre-existing rules for all water resources from the year 2014. That is 2 years.
So your argument seems to be a little bit internally inconsistent in that you're saying that they exceeded their authority because they did not do enough.
Well, I would say our...
Did I get it right?
Well, I would say our primary argument is under 12052-8C, which is that the rule contravenes the specific provisions of the law implemented.
Okay.
And that's the primary argument today. And the specific law implemented is 373.219 subsection 3. The issue in this case comes down to whether the administrative law judge properly interpreted the seminal case Connage versus United States. The administrative law judge turned Connage on its tail, upside down. What the administrative law judge concluded was that Connage prevents him from considering other legislation that was passed in the same legislative package in 2016 as the statute from which the proposed rule flows. At the same time, and as part of the same legislative package, an act called the Florida Springs and Aquifer Protection Act was passed. The administrative law judge interpreted Connage as preventing him from considering the impact of the entire legislation in para materia. Actually, Connage requires the administrative law judge to consider in para materia the entire legislative package that was passed as Chapter 2016-1 of the Florida statutes. And in so doing, he limited his interpretation of what 273.219 subsection 3, I'll call it subsection 3, requires the department to do.
Well, that being said, an issue here was whether the agency had the authority to enact the rules that it did, whether the legislature gave them the statutory authority to enact those rules, correct?
It's beyond that. It's not, it goes beyond that. It's whether under C, the rule contravenes the specific provisions of the law implemented.
And what are the specific provisions that are contravened here?
The specific provisions the administrative law judge concluded were limited to subsection 3, 373.219 subsection 3. However, Connage requires the administrative law judge to consider the entire legislative package, including Part 8 of what is now Part 8 of 373, the Water Resources Code. Part 8 is the Florida Springs Protection Act.
Well, Counsel, and so in tying that part together with subsection 3 of the reference statute, you seem to place a lot of emphasis on the term prevent, correct?
Well, that's our second argument. Our second argument is that even if you don't apply the tools that Connage requires for statutory interpretation, even the plain language of subsection 3 requires an enhanced standard, a harm prevention standard for the first time. And more importantly, it applies to only Florida's outstanding springs.
Right. So, but in focusing on the word prevent, how do we reconcile that with the minimum standards reference later in the statute, which suggests that is it a floor, and that there can be heightened standards as well, but it's just a minimum floor.
Yes, it does establish a floor, but the administrative law judge, and this touches on the issue of uniformity, and the administrative law judge determined, only looking at subsection 3 as a freestanding statute without referring to the Springs Protection Act, but as a freestanding independent statute, that the only purpose was uniformity, and therefore the department's rules adopted the same uniformity that was already in place before 2016. That is, the consistency that was established by the what's called CUPCON.
Right, but
rules.
wasn't there expert testimony that given new groundwater modeling, the CUPCON rules are sufficient to prevent harm?
What the testimony was is that harm was not being prevented. And the defense was that the only reason that harm has been occurring was because of poor modeling. The statute doesn't allow for the department to allow for poor modeling. It's an absolute requirement. It's a minimum requirement of preventing harm. And the way that the administrative law judge interpreted subsection 3 was first of all, it had to be read in isolation from the Springs Act. And number 2, all it had to do was uniformity and consistency. Well, that had already been achieved in 2014 through the CUPCON process, which is consumptive use, permitting, consistency. Before 2014, there was no consistency among the water management districts regarding permitting. So the department and the water management districts effectively created consistency. But the whole landscape changed dramatically with 2016, where not only subsection 3 was passed, which goes beyond uniformity. It allows water management districts to invoke more protective standards if the minimum wasn't necessary. But the Connage issue is important because even the administrative law judge found that had he been permitted to consider the Florida Springs Protection Act, he recognized that that creates a heightened standard, again, for just a small subcategory of water resources in the state of Florida. 30 outstanding Florida springs is the only subject matter of the statute and of the rules. And to interpret subsection 3 as simply adopting the same standard that predated 2016 is to render subsection 3 superfluous, meaning, or without any kind of independent meaning whatsoever. And one of the important statutory canons that Connage encourages judges to apply is a rule that would avoid rendering a statute a nullity. And that's exactly what, unfortunately, the administrative law judge thought he had to do. He thought he could not consider the new heightened standard of the Florida Springs Protection Act. Now,
what language in that act are you looking at to suggest that, subsection 3 must be interpreted in pari materia with the Springs Protection Act, and therefore the rule contravenes that overall interpretation? What language are you looking at?
The very first clause of subsection 3 states outstanding Florida springs. That is a brand new category of water resource.
Right, so the definition comes from the Springs Act, but what language in the Springs Act is being contravened?
Well, the heightened standard, the administrative law judge pointed to 2 sections of the Florida Springs Act. We can identify at least 2 more. The first one is 373-801-3B, which provides many of the state's springs are demonstrating signs of significant ecological imbalances, increased nutrient loading, and declining flow without effective remedial action further declines in water quantity and water quality may occur. This is only outstanding Florida Springs.
But that's a legislative finding. That's not operative language in a law, correct?
Well, the administrative law disagrees with that reading. Even the administrative law judge found that had he been able under Connage to consider the Springs Act, he would find that a heightened standard is applied for outstanding Florida Springs. And
Where does he specifically say that in his final order?
I believe it's paragraph 35 and 36 of his recommended order.
But doesn't he also recognize that under the Florida Springs Act, DEP is authorized or required maybe to promulgate rules consistent with that part? So why is his reasoning wrong that in considering the challenge rule here, he is limited to the text of the statute at issue?
Well, because I believe 373219 applies to a very specific subject, and that is permitting. So logically, the entire legislative package in 2016 amended different sections of the water code. And subsection 3 was placed where it was because it has to do with consumptive use permitting. So that's why logically it would not appear in the Springs Act writ large, and it was logically placed in the section that involved the specific subject matter of consumptive use permitting. But when we boil all this down, we reach a position where we can't read subsection 3 in isolation and render it a nullity. We have to give it some impact. We can't use subsection 3 as a basis to pass the same rule, almost verbatim, that was in effect in 2014. We have to recognize that the legislature changed the landscape dramatically, but only for a small subsection of water resources, that is outstanding Florida Springs, of which there are only 30 in the state. Thank you.
May it please the court. My name is Jeffrey Brown, appearing for the Florida Department of Environmental Protection. I submit that every issue in this case can be resolved based upon...
So as a matter of housekeeping, y'all are splitting argument, right?
Yes, Your Honor.
Okay. So
Yes,
y'all are keeping track of the clock, and you're going to stop when you're supposed to stop, right?
Yes, Your Honor.
Okay, go ahead.
I expect to be very brief. But as I was beginning to say, that every issue in this case can be resolved on a single sentence. The meaning of a statute is derived from the text itself, not a projection of policy preferences that might be derived from some other source. The argument as presented both in the lower proceedings in this case was that two sentences within an adopted statute should have the meaning that they prefer, that there should be a more stringent set of standards. Now, in looking at the text of the statute itself, it says two things. You got to have a rule that on water resource permitting for these outstanding Florida Springs, and you have to have a definition that's consistent with Florida water policy. Now, that's all the statute says.
Well, the statute, to be fair, also uses the word prevent. What meaning do you attribute to the word prevent?
Well, prevent, okay, now, I'm trying to back up the argument as presented in the initial brief. And as presented by the petitioners, the selection of the verb to prevent implies that the Florida legislature intended something different than what was otherwise expressed, that we have to read a lot into the word prevent. And I was, as an intellectual exercise, when I was looking at the statute, I pulled up a thesaurus, and I tried to select other words. And, you know, I was trying to figure out, okay, if I was trying to convey what they're saying through one word, what could I pick? None. It's the word prevent itself is a neutral term in the overall meaning of the statute. Very simply, the sentence doesn't make sense without a verb. And the closest other verb I could think of at the time was to regulate. But I think that if you're trying to follow the logic of the argument presented by the appellant, it simply cannot be reconciled with the text itself.
How do you respond to their argument that, look, subsection 3 has to be read in peri materia with the rest of that 2016 enactment?
Well, there is the statement, and this is the one sentence that's really relevant in the case, is the direction to provide uniform rules. And let's back up a little bit and consider how Florida water policy is developed. This is kind of a unique thing, where you have 5 water management districts with independent taxing authority and rulemaking authority to adopt rules within their own basin. Now, let's assume for a second that the statute considered in part uniformity for simply as a matter of fiscal restraint. You know, it would be more appropriate from an administrative standpoint for a state board, the department, or a state agency, the department, to create rules, to create one rule on a single topic than to have 5 separate organizations creating inconsistent rules. So no, it is not superfluous, and it does have meaning in and of itself.
If it has the total meaning in and of itself, then how do you know what an outstanding Florida spring is?
That outstanding Florida spring is derived, as I recall, and then I'll defer to Mr. Mayton on the additional time, is defined in the statute. It's a discrete set of outstanding Florida springs.
What's defined in the Springs Act?
Yes,
So this is where, I mean, if we look to the Florida Springs Act for the definition of outstanding Florida springs, then why shouldn't we also look to that for the substance of the standard?
Because there is a common understanding that when you're creating a statute, you organize things. You know, if you are, you know, by comparison, if you're looking at the Uniform Commercial Code, if you have a concept that's relevant to Article 3 on commercial paper, you may borrow a concept from Article 2 on sales. But in that specific instance, and I was thinking about this by comparison, Article 3 has a very specific way of addressing the contract concept of consideration. So that, you know, if you're looking at how you might draft a statute and you're trying to convey the thought of what the appellants say this means, it's a series of binary choices. You know, if I was trying to convey that thought, how would I do it? I might have said so in the statute. I might have put that language in Article 8 and provide express direction for the department to implement a specific direction. That's not what happened. It said only the rule has to be uniform. Excuse me.
So if I heard you correctly, you're making the word prevent synonymous with regulate?
No, what I'm saying is that it is a term that cannot be reasonably interpreted to have the meaning that appellants say it does.
Well, if you tie prevent to harmful, let's just assume for purposes of my question it has some meaning relative to prevent and harmful. What purported minimum standard could ever satisfy, or would be too weak under that standard to pass muster under subsection 3?
There is the catch-all within the second sentence that the definition of harmful to the water resources has to be consistent with Florida water policy. But as to uniformity, that was a legislative direction. There could be an argument that the policy approach selected by the agency was so ineffective as to be arbitrary and capricious, but that was not the theory in this case. Does the court have any additional questions? I defer my remaining time to Mr. Mayton.
May it please the court. I'm Tom Mayton with St. Johns River Water Management District. I'll refer to them as St. Johns. I'd be happy to answer any questions that the court may have, but I do have one brief point. But Judge Ray had asked a question about what does prevent harm mean. The phrase in subsection 62-42.402 sub 2, that rule, a part of the rule, closely tracks new 373.219 sub 3 by requiring applicants to demonstrate that a water use will prevent harm. So logic dictates that the closer a rule tracks the language of the statute, the less likely it is that it modifies or contravenes that statute. So I'm kind of dodging what prevents means, but what I'm saying is
Let me ask
that
it this way. If the goal of this subsection was just to create uniformity, why didn't the legislature just say that full stop? I mean, I'm trying to figure out what the legislature intended by the words on the paper that say prevent harm.
I realize that the wording of sub 1 and sub 3 are different, and the normal idea is to think that the legislature means something different. I kind of struggled to try to see what was the difference between not cause harm and prevent harm. At the end of the day, the water resource should not be harmed under either provision. So I'm sorry I don't have a better answer, but that's kind of where I ended up. If I can, if no one has a question, the one point I'd make is that at the heart of FSC's case is a fundamental misreading of two things. First, Connage, because the judge did everything that Connage told him to do, and he said step by step in the final order, I'm looking at this, I'm looking at the nearby statutes, I'm looking at all of the Florida Springs Act, I don't find it relevant. So he went through all those steps, they just don't like the result. The second thing is that FSC has a fundamental misreading of the plain text of Rule 62-42.402 sub 3 and two paragraphs within it. I'll just call it the subsection because it's a mouthful. Based on the use of the word or and between sections, paragraphs H and I of that subsection 3, all 9 paragraphs of subsection 3 have to be met. That includes demonstrating no harm to the water resources under paragraph G. And that's supported by district testimony on trial transcript pages 62 and 63. Basically, FSC contends that under the OFS rules, an applicant need not prevent harm to water resources under G if they propose to use water under an MFL recovery strategy under H. But that's not based on the plain text of the rule. Rather, it's based on an incomplete and inaccurate summary of district testimony about the application of statutory section 373.0421 to paragraph G of the CUPCON rules. And you can see that in initial brief at 32. Basically, their view is an as-applied attack on the rules, which is improper in a rule challenge, which is supposed to determine the facial validity of a rule based on its plain text.
Do you have case law that supports that position in terms of when you bring a rule challenge that's saying the rule contravenes statute, it's always a facial challenge?
Yes.
Okay, but do you have any case law to support that proposition?
There's the Fairfield Communities versus Flowak case, 522 Southern 2nd at 1014, 1015. It's a first DCA 1998 case, and Goldman versus Florida Department of Law Enforcement, 238 Southern 3rd at 110. That's a 2018 Florida Supreme Court case talking about rule challenge being a challenge to the facial validity. I may not have answered your question. I'm sorry if I didn't.
No, you did. You did.
So let me, I guess there was expert testimony that the historical deficiency wasn't as a result of the rules. It was that we didn't have advanced modeling, groundwater modeling like we do now, right? And if that's the case, what was the purpose of the legislation at all? Why was it even needed if the pre-amendment enactment rules were good enough?
I think it's part of the whole SB 552 that became Laws of Florida 2016-1 was to do more to protect the outstanding Florida springs. And part of that is to make sure that there is a uniform definition of harm, a uniform approach to ensuring that there's no harm to the water resources of outstanding Florida springs throughout Florida. In a way, it kind of creates like a minimum level, and as was pointed out, there's the last sentence of 373.2193 that says you can increase the protection, but this is going to set the minimum level.
So uniformity is this, I think your answer is uniformity, that the.
Yes, and they, I know they poo-poo that, but there are two different places in this Senate Bill 552 where the legislature directed DEP to adopt rules providing a uniform definition of harm to the water resources, not only in this OFS rule, but also in the CFWI rules, Central Florida Water Initiative rules, in section 373.0465, subsection 2, I think D1, they also directed DEP adopt uniform rules. So it was important to them. I'm not exactly sure why, but it was important to them. If there's any other questions, I'd be happy to answer them. Otherwise, thank you for your time.
Thank you.
To follow up briefly, the portion of the ALJ's order that suggested that had this challenge been made to the act itself in paramateria with subsection 3 is on 1324 of the record, which is paragraphs 35 and 36. Now, a word about uniformity. One thing that's important to remember is that before 2016 and after the DEP spent 2 years in the CUPCON process to make everything consistent around the state, at least 4 of the 5 water management districts. In 2014, all water resources of the state had the same uniform standards, including what are now called outstanding Florida springs. It was only in 2016 that the legislature carved out a special category, made that explicit in the Florida Springs Protection Act, and by in the kind of the introductory clause of subsection 3 referred to outstanding Florida springs. Anyone reading subsection 3 first before reading the act would immediately turn to the Florida Springs Protection Act, and it would be clear that this is a special category where uniformity is no longer the goal. There was already uniformity for what are now outstanding Florida springs.
Was that legally required? Was it legally required for there to be uniformity, or was that just a collection of water management districts that did so, or 4 out of 5?
I believe there's no statutory source of uniformity for all water resources. But in 2016, when the legislature is looking at the entire landscape of the water code, would reasonably infer that the water management districts coming off a 2-year process to make all the rules consistent would be something the legislature would reasonably have known about when they carved out the special exception for outstanding Florida springs. Thank you.
Thank you. Thank you, counsel, for your argument. So we will give these lawyers an opportunity to gather their stuff and proceed to the next case.